Welcome to our Community Legal Education webinar. I'm just wondering if everybody can see and hear us. Could you please raise your hands if you can? Yep, I can see some hands up there. That's fantastic. Thanks, everyone. Okay. So I'd like to start by acknowledging the traditional owners of the land, and at Legal Aid Queensland we acknowledge the Turrbal and Yugara people as the First Nations custodians of the land where our office stands and where we work to help marginalised Queenslanders uphold their legal rights in our justice system. I'd also like to especially acknowledge the important role Aboriginal and Torres Strait Islander people play in our community and improving our legal system. I'd like to acknowledge any Aboriginal and Torres Strait Islander people that are joining us today for the webinar, and thank you for your time, and also for everybody today in the role that you play within the legal assistance sector and working in this space. My name's Linda Richards and I'm the Community Legal Education Coordinator here at Legal Aid, and it's fantastic to be working collaboratively with the Office for Children and Family and presenting a collaborative webinar today. So I'm joined today by Kath Kerr, who's a social worker with Violence Prevention and Women's Advocacy team at Legal Aid Queensland, and also with Tracy D. Simone as our special guest, who is the official solicitor at OCFOS, which OCFOS stands for, Tracy, the
Office of the Child and Family Official Solicitor.
Thank you, for those people that don't know. So thank you very much for being here today. Just a reminder that this webinar will be recorded for community legal education purposes, and we put a copy of it up on our YouTube channel at the end of the session, and that's a great resource for any staff that may not be able to log in today. You will see on your screen that there's a little box where you can download the handouts for today. So there's a copy of the presentation there. There's also a copy of the framework that Kath and Tracy will be referring to throughout the presentation, and our newly produced DV guide, which is a how-to guide, which was a particularly useful resource for support workers. We do invite questions throughout the session, and Tracy and Kath will keep an eye on those questions, and we'll either answer them as we go, or we'll certainly have some time at the end to respond to those questions. So thanks again for joining us, and I'll hand over to Kath for our overview.
Lovely, thank you so much. So it's fantastic to see today such a broad range of legal and non-legal practitioners joining us. And the framework and the principles that we'll be talking about are for all practice areas, not only where domestic and family violence is the primary presenting issue. We really want to ensure that all legal and non-legal practitioners have a good knowledge in order to respond safely as soon as you become aware that domestic and family violence is an issue for your client, regardless of what their main issue for coming to you is. Domestic and family violence occurs across culture, race, all gender and sexual identities, economic, employment status, age and residence. And the goal of this session today is to take you through our recommended best practice principles, help you identify why the appropriate response is important, and how legal and non-legal practitioners can best do this in practice. Best practice is not static, so it continues to evolve as our research and understanding grow, and we recommend as part of best practice that everyone continue to develop the skills and their approach in line with any new recommendations. The framework and principles have been developed to assist you to enhance your work once you become aware that this is a safety concern in any matter that you're dealing with.
And I just wanted to add to what Kath had said. This is also about our moral obligation as solicitors and barristers to the people that we're seeing every day. And the reality is, of course, that many of the people that you will be seeing, particularly in your family law practice or your domestic violence practice, will be experiencing domestic and family violence by their intimate partner. But at some stage in your career, there are going to be some people who are at risk of lethality, at risk of death at the hands of their partner and perhaps the children. So it's not just about going through the motions of reciting legislation to them and giving them the legal advice. It's also about really thinking about the safety of your client at the end of the day and working out what's best for your client. And also acquitting yourself in a way that you feel confident that you've done the best that you can for that person. And I always think, you know, Rosie Batty had lawyers involved in her case, Hannah Clark had lawyers involved in her case, and you would just want to be sure that at the end of the day you've done the best to assist that person, not to put any pressure on you at all.
We'd also like to flag that if the content of today's talk raises any concerns for you, to please reach out for support. So you can speak with 1-800-RESPECT on 1-800-737-732 about any concerns you have for your own safety or someone else's, but also for professional support and debriefing around work in this field. So to build on the points that Tracy just made, why do we need to be taking domestic violence so seriously? So we as a community are talking more about domestic and family violence than we ever have before. So the media is covering domestic and family violence and domestic and family violence homicides more than ever. Research is being undertaken into the preventions and causes, and governments are implementing and funding awareness campaigns and support organisations. As this community awareness rises around the behaviours and attitudes that constitute domestic and family violence, not only are more people reaching out for support, but we as workers and community members are learning more about how we can actually recognise domestic violence, safely respond and act to enhance safety. More and more services and practitioners are receiving disclosures of or identifying risks themselves of violence and abuse, so we need to be prepared to for this as much as possible in order to respond appropriately. So we take domestic and family violence seriously because we know from the emerging data, so the 2016 Personal Safety Survey tells us that 1 in 4 Australian women and 1 in 13 Australian men have experienced at least one incident of violence by an intimate partner. And on average, 1 woman a week in Australia is killed by a current or former partner. We know that domestic and family violence is the leading health risk factor and cause of disability and death for women aged 15 to 44. This is higher than cancer, car accidents or heart disease. We're also learning a huge amount about domestic and family violence, not only from these personal safety surveys, but also from the research and data from the Australian Institute of Health and Welfare, the Institute of Criminology, and the Domestic Violence Death Review findings from the various states across Australia. So this data and research is showing us that there are distinct gendered patterns in the perpetration and impact of domestic and family violence. It's important to understand that the overwhelming majority of DV is perpetrated by men against women, so a gendered lens is important and helpful when identifying risk. However, there is of course diversity of experience in DV, which is particularly important when working with family violence or clients from LGBTIQ communities. These statistics paint a sombre picture about why practitioners must ensure we deliver a high quality service that does not exacerbate risk or re-traumatise our clients. The Legal Aid and QLS hope that these practice principles will assist practitioners once you become aware
from the child
experiencing or posing a risk of DV.
And I just wanted to add from the child safety corporate data, our data suggests that domestic and family violence is a risk factor in 55% of the households that where we found a child was in need of protection. So most cases that we deal with and that you deal with us will have domestic violence as a risk factor in the household, and overall 41% of households who have contact with us, which is obviously less because it's a broader range of households, so those who have been found, not in need of protection. So it's definitely a big factor in the work that's being done in the child protection jurisdiction. So
we'll just briefly step through what we're actually talking about here. So domestic violence is coercive and controlling behaviour by one person against another in an intimate or family relationship that causes fear, controls the other person, and is part of an ongoing pattern of behaviour. This behaviour can be physical or non-physical, and it sets up a power imbalance. The behaviours perpetrators use to establish power and the impact of these on victims' autonomy and their presentation will vary from person to person. The behaviours may include acts of physical violence, verbal abuse, sexual violence and coercion, property damage, psychological abuse and gaslighting, reproductive coercion, financial control, monitoring and surveillance, technology abuse, and systems abuse, where the person using violence uses legal processes to harass, intimidate, and exhaust their victim. On the slide there, we've got a copy of Lenore Walker's Cycle of Violence from 1979. So this is important to keep in mind because it paints a picture that there is a cycle that many victims identify experiencing. But it's very important to note that when you've got the remorse phase and the pursuit phase where things may be calmer, it's not a sign that that violence has actually ended, and it's in fact part of that continued manipulation and control.
What's reproductive coercion, Kath?
So reproductive coercion is where the capacity to make decisions around reproductive choices, so contraception use or pregnancy, is impacted or influenced or completely taken away by the perpetrator. So it can be around the use of contraception or pregnancy choice outcomes as well. So there are communities for whom domestic and family violence experiences and risks may be higher or compounded for reasons including isolation, barriers to services, or poor system responses. So these groups include Aboriginal and Torres Strait Islander women, women in rural and remote areas, young women, pregnant women, women with disabilities, women from culturally and linguistically diverse backgrounds, and LGBTIQ persons. There's further detail of the factors to be aware of in the framework document itself, which we would encourage you, of course, to read through. But we want to emphasise that it's important to be aware of the additional risks and vulnerabilities and adapt your practice to best recognise, respect and meet your clients' needs. This includes building and maintaining a workspace and practice that's culturally safe, accessible and inclusive. So just a quick note on the language that we're going to be using today. There is a range of terminology to describe and define domestic and family violence and the dynamics present. So we use the terms on the slide to indicate the dynamics as well. The terminology differs for many reasons, but we selected these when we were writing the framework to reflect the diversity in preferences. And we encourage you to reflect the language that your client is using rather than. So the terms of victim, survivor, and person experiencing violence is the person who has been harmed physically, sexually, psychologically or socially by the perpetrator of the DV. And then the perpetrator or the person using violence is the person who is exerting or attempting to exert the power and control over their victim. So what is this framework? Hopefully you have heard of it, but it contains 7 principles of recommended best practice that we will be stepping through in detail today. So this is a collaboration between QLS and LAQ, and about 18 months of work went into this document. It builds on some earlier versions from both bodies dating back from 2000, and I'm sure as you would know and understand, our knowledge around domestic and family violence has deepened and become more nuanced during that time, and it continues to grow. To develop the framework and the principles, we not only utilised the combined expertise of both QLS and LAQ, but we also consulted with a wide range of practitioners from different practice areas and legal sectors in order to develop a resource that's practical and adaptable to hopefully all fields of work. So this framework and its application should of course work alongside your own professional practice standards. And if there is any conflict between these principles and those practice standards, priority must be given to the legislation, codes of ethics, and any codes of conduct. So we're now just going to step through 2 additional key areas of practice that will assist in the understanding and adapting of the framework into your practice.
So I wanted to introduce you all to a model that we've used in child safety for the last couple of years. And as you can see from the slide, it's called the Safe and Together model. And I wanted to talk to you about the model and also about how it's being used in the child protection jurisdiction. The model is developed by a bloke called David Mandel in the US, and he has exported the model basically throughout the world in child protection systems. It's a child protection model, but it's all throughout the United States, Canada, heaps of places in the UK, Scotland, Asia, so Singapore, and across Australia, so particularly in Queensland and Victoria. We have it's really about competencies across the system. So in this case, it was the child protection system. We had a program called Staff at Child Safety, and where we trialled this model in our work, and it kind of spawned a couple of research projects with ANROS, which is the national research body for domestic and family violence, and an academic called Kathy Humphreys in Victoria. There were 4 research projects called Stacey, Patricia, Stacey for Children, and Invisible Practices. I went to the training when I first started working at child safety, and then realised that it was very applicable to a legal sphere. And we got David Mandel over to do a training session with my staff at child safety and LAQ, DCPL, and the Office of the Public Guardian, which was really good. That was 2 years ago. But it's led to us doing some really creative stuff with domestic and family violence in the child protection jurisdiction. And you might have seen the media release from the family court last week, where they are also going to use the Safe and Together model to train their family consultants and registrars.
That's good.
So the next slide is the principles of the Safe and Together model. So they're basically that you keep the child safe and together, or the children safe and together, with the non-offending parent, that you partner with the non-offending parent as a default position, and that's about being, effective and child-centered in our child protection response. And the third one is about accountability. So you intervene with the perpetrator to reduce risk and harm to the child. So just get you to move to the next one, Kath. And just to give you a bit more detail and a bit more of a flavour about how it works in practice, the model talks about pivoting to the perpetrator. So a lot of the stuff that we do, and I think child safety is very guilty of this in the past, a lot of the work that we do is with mothers, and a lot of the stuff that we write in court documents and in our applications is about what the mother has done to protect the children from the child, or what the mother hasn't done. And really, this model talks about, we're actually looking at the perpetrator's behaviour. So we're looking at the perpetrator's pattern of coercive control. That lots of you will have heard used very frequently recently. And there is a tool called a mapping tool, where you map the perpetrator's coercive control, which is really amazing when you see it in a document. And there's been cases where child safety have actually sat down and gone through all of their ICMS, their database, and mapped behaviour, and you can see a clear pattern of the person's behaviour. So the whole model looks at the perpetrator's behaviour and not the relationship or survivor's behaviour as the source of risk and abuse to the children. We look at the behaviour beyond the current partner. So as you can imagine, there are people with several partners and similar types of behaviours, so we would do that. It also highlights the choice that being violent and abusive and controlling is a parenting choice. So obviously if you're doing it in front of children, it is showing a parenting choice to children. We are encouraged to think about the impact of the perpetrator's behaviour on the family ecology. So how does their behaviour impact on the loss of income or housing instability, you know, punching holes in walls, being evicted, loss of contact with extended family, how that affects the children, educational and social disruptions. It also encourages us to look at how it impacts on the child. So how does it impact on their behaviour, their emotions, their development, their physical injuries, and the effect on the partner's parenting. So the triad that we see in child protection in many, many cases is domestic and family violence, mental illness, and drug and alcohol use. Getting a bigger picture of how us saying, and I encourage you to think about this as well, rather than us saying she's making sure that work comes through mentally ill, therefore she can't parent, to think about the pattern of domestic and family violence and how that's impacting on her ability to cope, her mental health, and her drug use. And we've certainly had cases where a person's partner is forcing them or encouraging them to use drugs. We look at, we're encouraged to look at the survivor's actions to protect versus what we would normally say in the past, which is this woman has, failed to protect the children. So you can probably guess so pivoting to the perpetrator is, turning your gaze, and the research project that was called Invisible Practices was really around that. So it's not just about the violence, but it's also about looking at the father as a parent and saying, well, what actually does he do in the parenting? Because certainly in our private lives, we expect men to be equally parenting with us, and it shouldn't be any different in our work life. So how is, asking, certainly in a child safety context, asking the man what he does for the children, does he take them to school, does he make dinner, all those types of things. So you're getting a bigger picture of how what's happening in the family. And we've used that to really influence the way we write affidavits. So making sure that work comes through, because I realise that everything we do would then be subpoenaed into the family court and then tells, starts the narrative in the family court. So it is actually important what words are used. So that's just an introduction. I think that's it. That's me, but that's an introduction to that model. And obviously you're going to see more of that if you have a family law practice.
And family violence.
The family court has adopted it as well.
Yes. So another framework or model that we used, that we built the framework upon, or that heavily informed how we developed the QLS and LAQ framework, is trauma-informed practice. So trauma is a common experience for those who have lived through or continue to live with domestic and family violence. It is an emotional response to experiencing or witnessing a frightening and all of the result of the brain threats, whether real or perceived, to a person's life or safety. The fear that's instilled by a perpetrator can often leave their victim with genuine beliefs that their life is at risk, and our intimate partner homicide rates do remind us of just how lethal that risk so many women are living with is. But during a traumatic event or a scary event, the amygdala in the brain sets off an alarm that there is danger. This then overrides the conscious brain and activates the survival response, so the fight, flight, or freeze. The adrenaline is flooding the body, and all systems not essential to that survival are switched off, or their purpose is changed, which can have a profound effect on how memories are stored. Repeated exposure to traumatic events, such as for survivors of domestic and family violence, can cause complex trauma, where the body's danger warning signal becomes jammed. A person can be significantly affected by anything that may remind them of their abuse, such as smells, a word or phrase, a colour, certain places, or a tone of voice. Compounding vulnerabilities, not only of trauma, but also of trauma-informed practice when working with domestic and family violence, in order to best offer an environment where not only clients feel safe to disclose and discuss their safety concerns, but also to have practitioners who are skilled at identifying and responding to their disclosures in safe and appropriate ways. We know now that poor responses to trauma can further isolate people who've already been marginalised by a system that they had turned to for help. So how can you identify that trauma may be a factor for your client? Well, it manifests in many different ways and many different behaviours, and all of the result of the brain trying to protect itself in the face of a threatening situation. So manifestations for clients may include where they struggle to recall events or struggle to recall them in a clear, linear way. Their story may jump around from place to place and not seem to make a lot of sense. They may have periods of vaguing out, but also in their presentation, they may be heightened or crying or even abusive towards you when you raise certain questions. But counterpoint, they can also be quite emotionless and disconnected when describing awful things. The other important thing is that often with trauma, clients will not disclose the violence upfront at all. So clients presenting with trauma can take additional time and patience to develop that rapport and that working relationship with, but also can take that extra time for you to get a clear sense of the whole picture of domestic and family violence if that's relevant to the legal work or support that you're offering to that client. So once you have identified that your client is living with trauma, you must adopt a trauma-informed practice. Already, the stakes and mishandling. I actually recommend using this approach in all work around domestic and family violence and with clients who have other compounding vulnerabilities, because this really helps us help our clients. This lens centres on an understanding of the impact of the trauma and helps you make sense of your client's presentation and why they may be reacting in a certain way to certain issues or certain triggers. Working from this approach, it really encourages you to create a working relationship with the client that promotes safety, trust, choices, collaboration, and empowerment. It also works really hard to avoid repeating the dynamics of abusive interactions or re-traumatising clients. So, for example, how you may be expecting your client to retell their story or safeguarding against their exposure to their abuser through any of the court processes. We should all ensure that we are not inadvertently recreating the dynamics of an abusive interaction. So this includes remaining mindful of the tone you're using to communicate and also ensuring that you're conveying respect for the client's capacity to make their choices and decisions. So we're now actually going to go into the nitty-gritty of the 7 principles. I'm going to highlight why they're important, and then Tracy's going to step through the practicalities of incorporating these into your practice. So while we've made significant progress over the past decade or so in enhancing
person too,
domestic and family violence, myths and misunderstandings still exist. So we must aspire to evidence-based practice and understandings, but also reflect on our own assumptions and whether they are helpful or correct when working in this field. We still hear myths such as a victim will always leave an abusive relationship, or that domestic and family violence will stop when the victim and perpetrator separate, or that domestic violence only affects particular groups. Holding incorrect assumptions such as these can actually result in interventions where risk is raised through a failure to appropriately consider the dangers present and address the safety issues. As we've mentioned a couple of times already, the stakes for mishandling DV are high, and it's also important to consider the risks to the well-being, mental health, as well as the physical safety of your clients if we're mishandling it. The knowledge and understanding of the dynamics of domestic and family violence, how that control can manifest, and the impact of those additional vulnerabilities we flagged earlier all help to inform the ways we work with clients and our capacity to offer and facilitate safe legal processes and steps.
So how do you do this? Well, obviously you do exactly what you're doing today, which is attending CLEs and reading information on domestic and family violence. You'll see on the screen there, use evidence-based screening tools. And I know certainly when I was at Legal Aid, we had a screening tool. I don't know if they're still using it, but we went through what's a good screening tool just at the first time you meet with a client, and then at important points along the continuum. And this doesn't just apply to family law clients or DV clients. It applies to all clients. I think if you are hearing things that you are thinking, gee, that's ANROW, might be a little bit dangerous. I did a quick Google before I came down here, and there's quite a few risk tools that you can use, screening tools that are available on the web. So there are options for you. There was one from New South Wales Legal Aid that looked fairly good as well. So I think if you are worried about something, a screening tool is definitely a good way to assess
Portal for the work around DV.
in terms of lawyering, but also who you would want to refer that person to. And there's a whole host of legislation that I would encourage you to have at least a kind of overview of. Obviously the domestic violence legislation, but tenancy, the family law legislation, so on parenting, child protection, obviously it's a very high risk factor in our child protection cases.
This can be in
the law. A lot of the women that you will see, and sometimes the men, have committed offences as a result of domestic and family violence. I remember that from my work at Legal Aid. And then also in immigration, I don't know if you have any contact with that, but certainly a lot of immigration, a lot of the visas that women are on, the relationship breaks down after they've come to Australia because of domestic and family violence. So just having a kind of cursory knowledge of these is very important, so that you're giving holistic legal advice. And the bottom point there, of course, is attend relevant training opportunities, which I assume you're all across because you're here. Just to point out that ANROWS is a really good website. That's ANROWS. They have lots of, when all of this stuff about coercive controls intact, as we know, they've got a really good fact sheet on coercive control, so you can get your head around that. But also they have lots of stats. They have fact sheets on all aspects of domestic and family violence. So I do recommend that website to lawyers and people working in the legal assistance sector. But also the Proctor this month has a few articles, and they have on an ongoing basis articles on domestic and family violence. So that even if you can't get to the other sources of information, they're a good one as well.
And Tracy, we can include some of those links in an email out to all registration
homicide. So that is.
And don't forget, if you want to ask a question, ask at any time. It's a bit hard with the webinar because no one's asking us questions. Don't know if you're hitting the right mark.
Okay, so now.
What was that website?
ANROWS, was it?
Yeah, so www.anrows.com probably.
So we'll definitely send that out in an email, a follow-up email after the webinar, just to confirm that. Any links, Tracy, if you want to send those through.
Yep.
Queensland now has their common risk assessment and safety framework as well,
Okay,
which is the one that Legal Aid now recommends that practitioners use.
How would they find that, Kath?
So that would be amongst the list that Linda will send out. But on the Queensland Government webpage, they've got the portal for the work around DV, and the recently reviewed version of that is now available.
Okay, that's fantastic. So lots of resources coming your way after the webinar today.
I think we might just need to click back over to the window so I can move us onto
There we go, back to the presentation.
So on to our second principle, which is to prioritise safety. So this is important for many reasons. So we know that clients who are experiencing or using domestic and family violence often connect with legal supports during periods of elevated risk. So this can be in the lead up to or shortly after separation in family advice, but also following police interventions. So we should never underestimate how DV can be life-threatening. Those weeks and months before and after separation is one of the most dangerous periods for intimate partner homicide. This risk does reduce over time, however, it rises again in the 12 to 18 months post-separation, and that's usually when family law proceedings for parenting or divorce may be before the courts. So these legal processes often indicate the finality of that relationship and erosion of the perpetrator's capacity to control their victim. So escalations of aggression and violence during these periods are often an attempt by the perpetrator to either regain that control or punish their victim for asserting their independence. During any legal proceeding, no matter what the area it is, risk profiles around domestic violence can change quickly and repeatedly. So this is why it's important to continue to screen for risk at each contact, as we know that legal proceedings also increase a perpetrator's capacity to have access to their victim. So whether that be through court attendance dates or even knowing what the address of their lawyer is, to continue to abuse, harass, intimidate, or even kill their victim. We've got some slides, some of the indicators here of that escalating risk or homicide. So you must take particular caution where any of these factors are present. So these are factors that have come up in the reviews by the domestic violence step reviews across Australia and internationally. So these indicate not only increasing risk of serious harm, but also of homicide. So that is the non-fatal strangulation, the separation, as I mentioned, the sexual violence, forced sexual acts, assaults during sex or sexual jealousy, threats to kill the victim or their children, threats of suicide by the person using violence, stalking and obsessive behaviour by the perpetrator
making sure
there's been violence against pets or companion animals. It's controlling it's increasing in its frequency.
Redact.
If the victim is pregnant, that also increases the risk, or the misuse of alcohol or drugs by the perpetrator.
And I know they're certainly saying the coercive, in this debate currently around coercive, of like what's in your court material, a risk factor for lethality. So we all probably think of someone at risk of dying through domestic and family violence being having a history of physical abuse, but in fact, I know certainly with the Hannah Clark type of scenario, that was all coercive control. So you shouldn't put all your eggs in one basket and keep an open mind about the behaviours. It's not necessarily going to be preceded by lots of physical violence, although I know it's always a red flag if you're hearing about strangulation. I know that's certainly one thing to worry about. Look, there's lots of things to worry about, but yeah, just keep in mind it's not just physical violence.
That's exactly right.
So I'm talking to you about how to prioritise safety. So we did talk before about the risk assessment tools, and I do recommend those.
Also an important part of a victim
is you're hearing from your client. So assess risk and then reassess risk at each, maybe after each court event, or if you've seen some behaviours from the other side that are worrying you. Think about their safety at the legal events. So think about their safety at the family court. I've always found the family court very good. If we tell them that someone's at risk, they do take steps to protect people. Think about your own interactions with the client, because clients may not necessarily be separated from their partner. Think about whether or not their partner's checking their phone, checking numbers. I know here at Legal Aid we've all make sure that when I was here we had every silent numbers, but it's worth having that conversation with your client early on. What's a safe way of contacting you? Is there any, did you want me to call at a particular time? And also, obviously, it's good to, it's essential to encourage clients to connect with domestic violence services or DD Connect to make sure that they've got a safety plan or some way of thinking about their own safety. The other thing that we certainly think for that person, it's really for you as practitioners to think about your own safety at court to make sure that clients are safe in seeing your client, making sure that the perpetrator is not hanging around outside your office, and taking any threats really seriously. So you just don't know, so you have to take every threat seriously and take appropriate action. And obviously, if you thought someone was going to come to harm, that is something that you can obviate your legal professional privilege and take steps to make sure that people are safe. The other thing,
The perpetrator.
not to have addresses or any identifying information on the outside of files so that perpetrators or people can see where the person is. And also one problem that we've had at Child Safety heaps and heaps of times is in court material, making sure that none of the court material alerts a violent person to their partner's whereabouts. So we've had terrible problems forgetting to redact a school name or a refuge name. So, you know, in the wad of material that's gone to both parties, we've missed a school.
We're not suggesting any
The perpetrator to where the victim and the children are. So these are all things that you need to be aware of, like what's in your court material, and also, you know, what safety do you need around your client and yourself. So
very practical advice and tools there.
So our third principle is to facilitate empowerment. So this is important because it's essential that victim survivors do not feel further disempowered or even further abused by a legal process. It also acknowledges that survivors can make their own choices when given information about their options. Many persons who've experienced domestic and family violence will have been prevented from making their own decisions and exercising autonomy due to the perpetrator's control. Legal processes can feel confusing and overwhelming for everyone, but they won't always be able to easily respond or adapt to the risk a client may be at, or at what point in the cycle of violence they're with, which can be profoundly influential over how safe a client is or feels to participate in the process itself. Facilitating empowerment is also an important part of a victim's recovery from an abusive relationship, and provides an opportunity for that survivor to really exercise and demonstrate their autonomy and prove to themselves that they have been able to do these things that were denied them by their abuser. Through victim disclosures, or
what types of things can you do to facilitate empowerment? Keep your client informed throughout the legal process. So make sure you're explaining the legal process to them, and giving them choice and decision-making ability, which is obviously a basic to legal practice. I do recommend providing your client with written material or links to internet resources, so that if they are overwhelmed in a legal consult, they can go away and read through the information that you've talked about. Make sure that they understand what's going on at every stage, and to give them, as I said before, the decision-making power. Ensure that they're able to make as many choices as possible regarding their legal matter. Don't pressure them into a particular course of action, even if you think that that's in their best interests. For instance, you know, I really think you should leave, and I don't understand why you're not leaving because you're really.
To this last point here,
when of course the reality is they might be even more unsafe upon separation. So even if you think it's the best thing for that person, it's really their choice. And also, you know, another way you can do it is to reality test potential outcomes to make sure that clients are safe in whatever circumstances they're in. I notice on the slide there it says adopt a trauma-informed approach. So as we discussed earlier, understanding that their behaviour, whilst it may be annoying when you're trying to get instructions, is actually as a result of the trauma that they've experienced, and to be very patient and understanding, and to make a referral.
so our fourth principle is
to control the.
So this is relevant when working with both the domestic and family violence victim and the perpetrator. The techniques that we'll talk about in promoting accountability can involve subtle shifts in language and our responses to clients. So a common situation that comes up is where a perpetrator has actually blamed the victim for the violence that they've experienced. So I wouldn't have hit you if you'd had dinner ready on time. This is a form of psychological abuse in itself, and it's important that we're not complicit in it. We also know that some victims will assume responsibility for the violence as part of their own coping strategy to feel that they have some control over when or how the violence happens. So I just give in so he doesn't get angry, or I stay out of his way if he's had a bad day at work. So coping techniques or views like this can actually entrench a victim in that cycle of violence. And it's important that when we are working with these clients, we're not suggesting in any way that they are responsible for the domestic violence. When we are working with persons who've used violence, legal practitioners in particular are in a really unique position. So you may be the first person your client sees as being on their side, the first person they listen to and trust who's advocating for them, or the first person that they actually need to do.
When I wrote about
So in circumstances where it is clear or accepted that your client is the perpetrator, you can draw this to their attention and their options to explore behaviour change as well. Tracy will explore in a little bit more detail, but it's really important not to collude with any perpetrator of violence with statements or attitudes that absolve them of responsibility for violent or controlling behaviour.
And when I did the second together,
why around promoting accountability is that it's really important because we're working towards long-term change. Ultimately, the only way to end domestic and family violence is for the person who is using that violence to change their behaviours. So if and when opportunities arise to encourage persons using violence to change their perceptions and behaviours, we should be taking full advantage of those. A key part of promoting accountability is also making sure that you can accurately assess the domestic and family violence dynamics present. Misidentifying a person using violence as a victim of violence can have profound impact on safety, such as validating their use of control or enabling them to use their victim status to further harm or manipulate the true victim. DV is not always easy to identify, and we know that it usually occurs through victim disclosures or when police attend or observe an incident. So we cannot assume that the legal position someone is presenting as, say as the defendant or complainant or the aggrieved or respondent, is a correct labelling of that. So it's important to hone your skills and your knowledge of risk indicators, dynamics and profiles in order to assess these dynamics yourself. The purpose of this assessment is to avoid inadvertently justifying or minimising DV, and it shouldn't be changing your legal intervention or advice around their options. So pay close attention to how your client treats or talks about their partner, their ex or a family member. So some of the points that can help are on the slide here, but you may observe that they dehumanise or pathologise their partner or family member. They criticise their partner's parenting without sound concern. They blame their partner or family member for showing no respect or being disloyal. They restrict their partner's access to services or always accompany them to appointments. They have control over the house.
oh, that's me, sorry. I was just making sure.
With their negative views about their ex, their partner or family member, and they don't take responsibility for their actions or they minimise their actions. So this last point here has relevant in distinguishing between a true victim and a person presenting as a victim. Where someone is a true victim, they will often take
only collect the minimum amount of
violence, but also for any of the aggression or control that has been used by the other party throughout the entire relationship. So these are
and recognise that there may be different
queries or factors that have come to us through the running of men's behaviour change programs and persons who are using violence and the work that's being done in that field.
And Kath, I know certainly from what we've seen over at Child Safety, the first person to contact the agency is not necessarily the victim of domestic violence, but you can see when they cross family law and child protection jurisdictions that they are using systems to control the victim, to get the children, to yeah, it's just that systems abuse and being aware of it. And you're not necessarily aware of it because you're seeing them in a particular context about a particular event, but when you look at it across a bigger or a broader framework, you can see the tactics. So my notes are important. Work with the victim, it's important to acknowledge that domestic violence lies with the perpetrator.
Also be compounded by
I certainly think that it's okay to say to someone, you didn't deserve that. That's, you know, not your responsibility, that behaviour. I know that the hardest thing,
survivors may be reliant on their
a respondent to a domestic violence order who denies everything. And obviously there's not much you can do with that except take your client's instructions and give them.
that your client isn't left in
The point about colluding with perpetrators is a very good one, and to be very conscious of your language and behaviour. And as I said during the Safe and Together model presentation, it's not about concentrating on what the victim has or hasn't done. It's about
to speak with you about the details
perpetrator and how their behaviour has impacted on the legal situation. One of the regrets I have with my family law practice, including as an ICL, was when I wrote about domestic violence, I often mutualised it. So I would say that, you know, the relationship was characterised by domestic violence, or there was domestic violence in the relationship, and that doesn't really name the perpetrator, does it? It's not making the perpetrator accountable. It's kind of making the violence external to the perpetrator, or, you know, relationship based. So it was the relationship that caused the violence rather than the person who actually did it. And when I did the Safe and Together training, it really, I thought back on all those cases and how I had portrayed the violence and thought, oh, I wish I'd done that better. But anyway, we live and learn. And again, minimising collusion. So just be careful about what you say, and you know, give access to another gender, and so best in the situation, because it is a hard situation to be in when you suspect that someone has been responsible for violence, but they're denying it, and there's not really anywhere you can take that. My notes say, listen carefully and pause to think about the impact of your answer where your client may be trying to get you on side, or have you agree with them that it's their ex who is a psycho. I don't know if we're allowed to use those words anymore, or provoke them and that things weren't that bad. So there should be a way to establish rapport with your client without colluding with them. And finally, just to remember, don't suggest couples counselling to your clients where there is domestic and family violence, because that's obviously not going to be a good result for the victim or survivor. And there is an article at the bottom of the slide there about what we've done in child protection and the representations in court material, if you're interested.
Great, and we can include that reference in the email as well.
Excellent. Yeah.
Helps us not only respond and behave. So our fifth best practice principle is to communicate respectfully and appropriately. So safety is enhanced and risk is mitigated when both the victim and perpetrator have a clear understanding of the legal process, their rights and their obligations. But it's important to communicate not only in a way that conveys clients in retelling their experience, but also encourages people to remain connected with and engaged with processes and services, as this works to enhance safety through systems connection. We want to ensure that clients will continue to reach out for support when they need it and not feel dismissed, diminished or excluded by the responses that they receive.
Sorry about that, Kath. We were just checking the questions that we've received from our participants. So I just needed to change the view there.
Oh, that's me, sorry. I was just making sure that we didn't miss any of the questions. So how to communicate respectfully and appropriately. Again, using non-judgmental communication. So instead of saying, why haven't you left? Perhaps I lied. I'm sure you know a history of the relationship and what's been happening. Respond sensitively when clarifying or asking for further information. Only collect the minimum amount of information required to determine risk and inform your legal work. So don't ask detail out of curiosity. Use plain language. I'm sure you're all across that. And recognise that there may be different responses to domestic and family violence. So I can definitely confirm that. As you would know, some clients may be upset, some clients are angry, some clients you think are out of it or detached, and these can all be normal trauma responses. Some people are ready to discuss the domestic violence and then others aren't. But again, if you're sensitive and patient, then you can work through, it may take a few more appointments, but you can work through getting the information that you need. Yeah, I've said again, I think it's you're allowed to say, look, that behaviour is unacceptable. Child safety, who else? Number 6.
So not all experiences, as Tracy said, or manifestations of domestic violence are the same. So we need to be able to recognise the diversity and the needs our clients have in connecting with services and remain mindful of the factors to be inclusive and accessible. So clients' needs may be practical, emotional, social or cultural, and all of these are important. How clients are impacted by their experiences of the legal systems can also be compounded by language, accessibility or cultural assumptions. So building on those communication points from the previous principle, it's important that clients aren't isolated from support if their needs are not responded to respectfully. Some survivors may be reliant on their abuser for their daily care needs. So we should be aware of when and where to refer clients to for support or brainstorm for other safe or trusted persons so that your client isn't left in an even more vulnerable or isolated situation if their abuser is removed from the home. For LGBTQ clients, you may need to build trust that they will not be met with homophobia or transphobia before they disclose any details about their relationship to you. And practitioners also must be aware that discussing domestic violence is taboo in some cultures, or there may be rules about who the violence can be discussed with, and to check this with the client if they're comfortable. Thank you. Or how or who they could tell those to as well if it's not you.
So obviously how to do
Queensland, we also have 1-800
based on someone's appearance. So if they're Muslim, not to make assumptions about that, or if they're from some other culturally or linguistically diverse background, not to make assumptions about that, but to ask
other services webpage.
Don't make assumptions about their cultural or religious background. They may not follow those particular conventions, or you just need to discuss it with your client. Use inclusive language, so in terms of people's gender, their pronouns, you know, their sexual orientation. Use very open-ended questions. Don't assume that they're a she or a he, you know, they may be a them. And mislabeling can be a form of emotional and psychological abuse. Certainly my daughter's told me that that's called dead naming, if you use somebody's name and they've transferred to another gender, and so you don't want to be abusing your client in your first session with them. So also avoid making assumptions about sex and gender of your client and the other party. Obviously, in terms of people with disability, make sure that your offices are accessible, so wheelchair access, and, that you have telephone interpreter, and that you can offer electronic meetings. Well, of course, we all do these days, but ensure that the way that you talk is being understood by the client.
And our final recommended principle is to collaborate with other services. So domestic and family violence requires a response beyond the legal system, with different stakeholders holding different responsibility, expertise and capacity to enhance safety. There's a whole range of services that can and should fit together to enhance this safety. So counsellors, crisis services, DV organisations, behaviour change programs, medical practitioners, housing supports, financial aid, child safety, they are all part of this picture. So be aware of the relevant services, who they are, how they helps us not only respond and refer appropriately, but also ensures that in contexts where there are multiple agencies present and supporting your client, everyone is on the same page, and it also enhances the chances of the vulnerable clients of being connected with the right services. Information sharing where it is lawful and appropriate can also minimise the trauma associated with clients in retelling their experiences to multiple agencies. Metaphor concepts, so survivors disengaging from systems. So our efforts to promote safety and mitigate risk, including the legal options and intervention, back to you what if we're working with other stakeholders to ensure gaps are best addressed and survivors and perpetrators receive consistent information and reinforcing messages and interventions.
So for those in Brisbane and for those in regional areas, it's very important to know the legal and non-legal supports in your area. Many of our regional areas have domestic violence services and domestic violence refuges, and there's obviously quite a few in Brisbane, but also knowing that there is.
So thanks for that, we really appreciate it.
Here in Brisbane, that you can get migration advice from Rails and how you get in contact with them, getting tenancy advice for your client. I'm sure people from community legal centres are across what the other centres do, but for the legal aid preferred suppliers, knowing that those services are around is very important. So as Kath was saying, do you know your local drug and alcohol programs, where you can get medical assistance, where you can get financial assistance? And I know in the notes here it's saying particularly if someone's come to you after being physically assaulted or strangled. So obviously you need to get that evidence, and sending them off to a local medical centre where they can get that documented is very important. As well, minimising the need for survivors to retell their story. So I suppose if you're referring someone to a service, getting permission from the client to actually give, I think you call it a warm referral, but to give information to the service prior to referring them so that they don't have to go through the whole story again is always helpful. And I see on the slide they have asked whether you have a regional high-risk team. So many of the regional areas have a high-risk team, which involves housing, police, corrective services,
Child
safety, who else?
The regional DV service and
health.
the court.
Yeah.
Yeah.
And they share information about local cases where there's possible high risk to a family. So
who facilitates that one, Tracy? Is that a Queensland government?
Yes, Queensland government, but I don't know which department. But certainly your domestic violence, and yeah, your local domestic violence service would know how to refer to those high risk teams. And obviously we all have legal professional privilege, and you have to manage that. But certainly if someone's at risk of
and we are relying on you also.
Exemption from legal professional privilege, because you would be wanting to make sure people are safe. But that's a Law Society question, so I would encourage you to talk to them. Yes.
Okay, so that is the overview of the whys and hows to use the framework. So it's at the hyperlink on that website, on that slideshow there, but you can also find it on both the Legal Aid Queensland and the Queensland Law Society web pages. So I've just put the links that you'll find it under there.
Yeah, and it's also attached to your handouts on the webinar today, so you can be downloading it.
Hopefully it will be helpful in that Tracy and I have been able to give a little bit more practical context for how you can be using that as you go through your work with your clients and identifying when it may be most helpful to be using. We've also got here some referral numbers as well for Queensland. So I'll just move over to the next slide there, Linda. Thank you. So we've got two of the big services here for women. So DV Connect is the crisis service for emergency accommodation and urgent safety planning across Queensland. We also have 1-800-RESPECT, which is phone counselling for experiences around domestic and family violence and safety planning. So we strongly encourage you to also know who your local regional DV support service is. So you can find these links on the DV Connect Other Services webpage or under the Domestic and Family Violence Community Portal on the Queensland Government website, where you will also find the Common Risk Assessment and Safety Framework. The two key services for men are DV Connect Men's Line and Men's Line Australia. So DV Connect Men's Line is the Queensland-based service, so they provide support over the phone for counselling. They also do the referrals for behaviour change programs and referrals for local services. They work with both men who have used and experienced domestic and family violence. Men's Line Australia is 24 hours and they do support around relationships and domestic violence, but also parenting and wellbeing. So we know that a lot of our clients who are connecting with us do need a more holistic support framework. So Men's Line Australia are fantastic at offering that bigger picture. And then the other two big ones to be aware of are Kids Helpline. So they do support for children and young people for people aged 5 to 25 around family issues, feeling unsafe, bullying, family violence and gender identity as well. And then there is the Rainbow Counselling Service under Relationships Australia. So this is a counselling based model. It's not a crisis service, but it is one of the specialised support services in Queensland for people of diverse bodies, genders and sexualities as well. And they have a focus on safe and healthy relationships, which includes DV. So we now have some time for questions. Linda, I'll let you pull up.
Thanks, Kath. And I just invite people to, when you see the question box, you can type in a question there for Tracy and Kath. We've still got some time in the session, so it's a good opportunity to ask any practical questions while we've got the expertise here. So far we haven't had that many questions. The other option is also sending in a question to our webinars email address, and that is webinars@legalaid.qld.gov.au, and we can certainly get back to you in the coming week with any responses to those questions. So we'll just have a look at what we've got here. Tips for people working with people with intellectual disabilities. That's a good question, so I might pass that over to you both.
So there's a fantastic organisation, Wild, that is a great place to go to for tips and practical tips for working with women who may have an intellectual disability. It is really important to use the clear language and to use tangible explanations and not to speak in broad metaphor concepts. So that's something that I do struggle with myself, but to really slow it down, to check for understanding and to check for understanding in a couple of different ways, and to ask your clients to explain back to you what their understanding of what you have said is. But I would strongly encourage looking at the resources that Wild has. They have some fantastic posters that you can use that identify domestic and family violence in accessible ways for both clients and also tips for language to use for practitioners as well.
Thanks, Kath. And sometimes it's often knowing how to use a particular question, isn't it, to bring out some response from the client to give more information. And I think those screening tools that you were talking about, Tracy, have some really practical examples there. Any more questions? We've got some good feedback coming through, so thanks for that. We really appreciate your feedback.
It's coming through FDB. I see from Oliver that you're saying going through FFDB, but I don't know what FFDB is, Oliver.
Sorry, mistyped. That's okay. I guess so. It'll be great if everybody can check out the best practice framework online and familiarise yourself with the framework and the tools there, and to promote it with your colleagues, whether you're a non-legal or legal practitioner. Certainly the practical tips that you've both provided today have been very, very helpful, and I think the how and the why also have really illustrated how people can incorporate the framework into their day-to-day practice.
Also a question there as well about accessing the regional high-risk teams.
Yeah.
So the best pathway to find out information about how you're, because they all do operate slightly differently, is through the regional DV service. So they will know how the high-risk team is meeting, but also how they are accepting referrals in or how they are taking cases. So some do operate directly from the DV service, some have multi-pathway referrals in, so it does vary, and that's probably the clearest and most straightforward way of getting that accurate information about what your local high-risk team is. Not every region does have one. They are still developing and growing across the state, so it's important to also check whether there is actually one in operation in your area as well.
Fantastic, thank you, Kat, and thanks everyone for your questions and feedback. We'll just give it another minute or two, and if there's no more questions for now, we'll close the session. But while we're keeping an eye on the question box, I'd like to thank you, Kath, for your time today, and for you, Tracy, for your expertise, and very much demonstrating how important the multidisciplinary approach is to working in the family, domestic violence and child protection space. So, and of course, also illustrated by who's here today, because we've got legal practitioners, we've got support workers, we've got government agency workers. So really getting that message out, and we are relying on you also in the sector to share the resource and promote it and bring it to life, really, for the benefit of the community. So we'll just do another quick check. And I think that might be it. So thank you very much, everybody, for attending today, and watch this space for continued CPD as well as community legal education sessions. You can check out Legal Aid Queensland website for more information, and you can certainly subscribe to our webinar email list to hear about more sessions like today. So thanks again.
Definitely, Rebecca, share the PowerPoint in the workplace.
Great.
There's no copyright.
Okay, thank you very much, everybody, and thank you again, Kath and Tracy.
Thank you.
Thank you.